Hey there, welcome to Cable Plus Property, your number one online educative platform on all issues related to land and landed properties. As you already know from our previous videos that you've been watching, this channel is dedicated to educating and enlightening the public on all issues related to building construction, documentation, obtaining planning permits, everything that has to do with land and landed property. My name is Oiza, and do make sure that you share, like, and subscribe to our channel and share this video with friends and colleagues. Securing a genuine piece of land can be very difficult, and this is due to issues like unclear records, unclear land titles, corruption, and so many other factors like that. This is why I have Dr. Akintunde Otubu, an associate professor and an expert in law, to come educate and enlighten us on these issues. So you want to sit back, relax, and enjoy the video. Don't go away, we'll be back. Dr. Otubu joined the Department of Private and Property Law, Faculty of Law, University of Lagos in 1997 after a stint with the Faculty of Law in State University, now Olabisi Onabanjo University, Aboiboye. He obtained his LLM from the University of Lagos in 1995 and PhD from Obafemi Awolowo University, Ife, in 2015. He was a joint winner of the Femi Okulu Research Grant in Property Law and a member of the Faculty Research Committee. He is currently a member of the Board of School of Postgraduate Studies, University of Lagos, and is also serving in the Curriculum Review Committee of the school. Dr. Otubu also serves as member of the Faculty Examination Malpractice Committee and the Faculty Coordinator for College of Negotiation, University of Lagos. He's a scholar of many parts and has diverse interests. He teaches land law, conveyancing law, housing law, environmental law at undergraduate level, and secured credit transaction, planning law, and compulsory acquisition law at postgraduate level. Dr. Otubu is an associate member and one-time chairman of the examination committee of the Chartered Institute of Marketing of Nigeria and a fellow of Institute of Security in Nigeria. His main area of research includes land, housing, and environment. He's a co-author of the book Land Use Policy and Management in the 21st Century Nigeria, Need for Reforms, published by the Department of Private and Property Law. Dr. Akintunde Otubu is a renowned author who has published widely in both local and international peer-reviewed journals. So dear viewer, join me as I have a conversation with Dr. Akintunde Otubu. It's a pleasure having you, sir.
My pleasure too.
So let's kickstart the conversation, sir. We'd like you to kindly explain to our viewer in very simple terms. We don't want the law jargons. What is law and why did you specifically choose to study law?
Well, let me just explain law in one sentence. It is the rule of life. These are rules that guides any organization, any association, actually anywhere where you have more than one person. So any rules, any regulation put in place, it is what is generally referred to as law. Though the philosophers may have some technical meaning to it, but the only thing I can say that law itself is ubiquitous. You find it everywhere you go. To the layman, if you see somebody sleeping with an open eye and snoring, you are likely to query it. Why are you querying it? Because that man, the person sleeping, is sleeping against the law of nature. Because by nature, you are supposed to close your eyes and you sleep. That is the nature of law. It is found everywhere. So it's the rules of conduct in any society, in any organization, in any place where you have more than one person. Even at times when you have one person, there will still be law. Because you may have a rule guiding yourself. So that when you preach that to you yourself, you know that local have gone against my principles. Something like that. So law is there everywhere.
So why did you choose to study law as a person?
Well, it's a long story. I don't know, but I think I just have this flair for equity. I have this flair for fairness. I think by nature I'm humane. I want everything to be balanced. You know. And I think I have this propensity to explain things, to make sure that you are satisfied, you know, and get things going in between or among people around me. And I think that influenced my choice to be law. And also, I think that character in me must have been seen by some of my friends and colleagues, because when I was young, I started my education reading I started my academic university education in the Faculty of Education.
Oh.
Yeah. Okay. But I remember my friends telling me, look, okay, the way you do things, you'll be a good teacher, you'll be a good lawyer. So fine. Then later I changed to law. Here I am today, and I'm not regretting it. So I've combined both law and education together, because I'm a law teacher today. So I'm a lawyer, I'm still in education.
Wow, that's impressive. Well done to that. So oftentimes you hear people use words like rule of law. What does it mean? In particularly rule of planning law.
Okay, well, you've laid the foundation, you've laid the guidelines in layman terms. You don't want all the jargon, the technicality of it. Rule of law simply means the supremacy of the law to the rule of men. Everybody, Tom, Dick, and Harry, are all under the same one law. And law rules in every circumstance. Irrespective of your size, irrespective of your status, you are bound by the law. You respect the law, you obey the law, you are obliged to comply with the law. So where we have that, then we have the rule of law in place. As a concept, yes, it is there. But in practical terms, it may not. Because at times, even in reality, we see some exceptions to it, but I don't think that is what you are interested in. Rule of law simply means the supremacy of the law over the rule of men in all circumstances.
So let's bring in...
Now, bringing it down to planning, it simply means rules of planning supersedes whatever planning arrangement you have in mind or you want to pursue. It must be in accordance with the rule laid down by the planning regulations. Unfortunately, planning regulations are usually preconceived ideas or rules. So they project. So you meet them up front before you even come out to put your planning arrangement in place. So there's rules that supersedes every other rules when it comes to planning regulation or executing a physical planning arrangement.
Having established the fact that the law supersedes whatever choice you may have as a person, can we then say that there are consequences when you disobey the law? And what are the nature, or what is the nature of these consequences?
Okay. Well, let me first start by saying law is a continuum, but for the purposes of understanding and appreciation, it is broken down into parts. Now we have criminal law, family law, land law, and all those things. So now to come to the issue of consequences. Based on the classification of laws in place, the consequence may be punitive, maybe penal, or maybe just damages. If it's a crime, for example, you may be sentenced, you may forfeit properties, you may be made to serve community services, and if it's in a civil case, then you pay fines, you pay damages, compensation, and so many other heads of remedies that are consequences of abridging the law. It may be specific performance, it may be an injunction. These are some of the consequences that may result from you offending the spirit and letters of the law.
So the nature of the consequence, we can say, is dependent on the kind of law you have.
Exactly.
Now, another concept you will hear people say when it comes to law is innocent until proven guilty. Can you explain this? And then, is it applicable to all situations? Like somebody kills somebody, or does something, and you say, "Oh, that person, you cannot hold him guilty until it is proven." Is that how it works?
Yes. You see, for every action or conduct, when it is to be established, there are usually two processes involved. You have to establish the fact, you have to establish the procedure at arriving at that fact, for that fact to be taken in as being presented. Now, having said that, the law is that every person is presumed to be innocent, because until it's otherwise established by those two levels, facts and procedure, everything is in the realm of allegation. And the law has to be like that in order to preserve and protect the human dignity and liberty, in order to preserve the society from what we call jungle justice. So you have to establish that the person actually committed the infraction, and in this particular way, you have to establish it. So the presumption that everybody is innocent until found otherwise is a maxim of common application.
All situations.
Or in all situations.
Okay, let's talk about the Land Use Decree of 1978. Why was it promulgated? And then what are the implications on land acquisition and planning?
Yes, Land Use Act. And that is the alpha and omega of land management rules and regulation in Nigeria today. Well, the reason for its promulgation can be found in its preamble and in the white paper that was published before the promulgation of the decree. And essentially, there was a story behind it. You see, prior to its enactment, the government found it difficult to get land for public developmental purposes. There were insider dealings. People in the government offices, knowing fully well that government is about to maybe construct an overhead bridge somewhere, maybe in a plan, say in the next 3 or 4 years, they go to that area, acquire the land in that area from the peasants, and wait for the government to now come. So when the government comes for, the government will have to buy, more or less, the land from them. So there were so many speculations. And the cost of land was so prohibitive for governmental development. So that was one of the reasons, or some of the reasons why the land was, apart from the fact that the government wanted to unify the diverse land tenure system in various parts of the country, the north and the south, so that we have a uniform one. So those are some of them. And the implication of the Land Use Act to land development and planning, the fundamental one is to be found in section 21, 22 of the Act, which is the issue of consent. And the fact also that proprietary right in land has more or less been converted to leases. Because before the Land Use Act, you have unlimited duration of tenure. But after the Land Use Act, you have a limited duration, which can expire. So to that extent, we refer to it as more or less like a lease. Understand? So, and the implication is that there's nothing you can do. One, the implication of that is that, look, you have a limited tenure over land. Two, there's hardly nothing you can do vis-a-vis the land in your care without going back to the governor for approval, consent, or whatever. It was supposed to be an administrative procedure so that the government will be aware of what is going on with land in its precincts. But it became something else. It became an albatross hanging over any dealing involving land. It became a money-making venture. And that brings us to where we are today, with land matters.
So how genuine is the land or the piece of land that is sold by families to developers after the Land Use Act?
It depends. You see, let me first say this. The Land Use Act under Section 1 vests all lands in a state in the governor. Of course, excluding Section 49, excluding those lands already vested in the federal government. Now, to that extent, it is the state that determines the scope and application of the Land Use Act. So it has never been uniform, because what you get in Lagos State may not be what you get in Ogun State. Now, having said that, the governor is empowered to divide the land of the state into urban and non-urban areas. Now, it is also incumbent to know that the Land Use Act recognizes existing rights in land, including rights of customary owners. That is, if your land is in non-urban areas, then you are a customary owner, and the law recognizes that, okay, you can be registered as a customary owner of that, or let me say, a customary right of occupancy in that area. So as to the effect or the implication of developers buying land from families after the Land Use Act, it now depends. If the land is in urban areas declared by the state, the law is that only the governor has the right to allocate or more or less deal with the land in that area. Not only that, in Lagos State, for example, by a land policy of 1981, I think it was Governor Latif Jacob made it. Lagos State was declared, almost all lands in Lagos State was declared to be urban. So taking away the bulk of the land from the non-urban areas. And with that, it means that it is only the government that can deal with those land in urban areas. And in furthering of that policy, not only that the government declared most of the land to be urban, then there was also what we later learned to be a global acquisition in almost all parts of Lagos State. And that means the state has taken over all those lands. So if you now have to buy land from a family after the Land Use Act and after all that policy proclamation, then become a suspect. Because that means you are more or less buying a state land.
So
from
how
the
is,
landowner.
I think that leads me to the next question. How can the title on such land then be obtained from the government? How can they be obtained from the government?
Well, it depends on the status of that land. If the land is, like I said, it falls within global acquisition area, then you cannot directly go and buy from the family. If you do, you still go back to government for ratification of that. And that will only happen if the land in question has not been a committed acquisition. If it's a committed acquisition, for example, the government has already said that land is meant for an airport, it's committed. If you go there after buying from the family, the government will not ratify, so you probably have to go to the family and fight it out to get back your money. But if it's still an committed acquisition, then the government is likely to give ratification to that sale, which means you are going to more or less buy it again from the government. Now, if the land you bought is under acquisition, another way by which you can regularize the position is that the family may now apply for a cession, which is an application to the governor that, look, yes, we know you have taken all this our land, but exercise this part for us so that we will also have some land for developmental purposes. So if a cession is granted and it covers that land you are buying from the family, then it will be okay.
Wow, that's very explanatory. Thank you for that, sir. Our next question is, what are the types of title documents on a landed property that are legal tender? You know, when you watch the advertisement of these developers, some of them will say, oh, there's deed of assignment, there's C of O, there's this, there's that. But you find out that not many people are aware which of these titles you can tender legally. So which of them? What part of them?
Okay. Let me first say this. I will still want to say something about those developers advertising. Yes, particularly when they say they have C of O, I'll come to that. But generally, what validates your title is whether it is registered or not. Otherwise, you have a equitable right. Yes, it's not as if you don't register, you don't have a right. But whoever registered before you, except you can establish fraud, will take precedence for you. So registration of your interest in the land, in the property, is actually that what gives you a priority over the land and over others competing with you. Now, having said that, before the Land Use Act, the title you have, the valid title you have over land depends on your interest. You are on the interest you have in that land. If you are the owner, then you can have a registered title. If your property falls within Cap 121 of those days, you can have a deed of conveyance, which records the transaction, or you are the first registered owner. Everything must be registered. Now, if you are not the owner, your interest is of a shorter duration. Say, for example, I own the property and I'll give you 50 years use of that property. Then what you have is a lease. It's also a valid title, registered also. So that means for that 50 years, you have exclusive possession of that property and you can make use of it. Only that you cannot sell it. Even you can sell, you only sell the interest you have in the mother code, and you cannot go beyond that. Now, you may also have a mortgage. Yes, that's another valid title, registered of course, which means that, yes, I own a property, but I needed money somewhere, and I approached you, you gave me money, and I exchanged it with a document of title saying that, look, hold on to this property for 10 years, for so long until I pay you back. That's still a valid title. So it depends on your interest you have. Now, after the Land Use Act, all these titles are still valid. Yes, they are still valid. Because by Section 48, the previous existing title and interest in land are actually recognized. But superimposed on these titles is the document referred to as Certificate of Occupancy, that is the CFO. That is an additional document of title introduced alongside the existing ones. So from 1978 to date, you could process title document which is known as Certificate of Occupancy. Now, beyond that, I referenced the other time the issue of government taking the land and then government releasing part of the land to the family. That's accession. If that accession is gazetted, it's also a root of title which can lay a foundation for your interest in the property. So these are some of the titles valid under the current law.
Okay. On what conditions can two certificates of occupancy be issued on the same plot of land for two different people? Is that possible?
I think you've answered the question rhetorically, which is that it is not done.
Okay. All right then. So, but what happens in a case where there is probably
if you have a situation of such,
a conflict?
Yeah, if you have a situation of such, I have already said this earlier that your interest in landed property is recognized by registration. So if a CFO is issued in the first instance, and it has been, definitely that CFO is registered, except that one, the first issue has been revoked. No other one can be issued with respect to the same land to another person for obvious reasons. One, by provision of the Land Use Act itself, you cannot, that is, I think Section 5 or so, you cannot revoke, and you cannot have two conflicting titles over the land. That one has been established by case law interpreting that section. Now, beyond that, the general rule of law is never that code don't have it. You cannot give what you don't have. When the governor issues the first CFO with respect to land A to me, that land A is no more in his possession. So he cannot issue what he doesn't have, land A, to B, to another person. So that.
The issue of land grabbers is quite alarming in Lagos State, you agree with me? And it is one of the factors that's been found out to be responsible for illegal construction because buyers want to physically possess their land. How can this menace be curtailed according to the law? Are they even supposed to exist? Are they legally existent? Okay,
let's look at it from this way. Yes, there's a law. There's a law against property, something in Lagos State. I think it was made in 2017, which seeks to curtail the activities of land grabbers. Yes, the law is there. But the law is not achieving its aim for various reasons. You see, it is the law is looking at the symptoms, not the causes. It goes deeper to understand why we have this problem of land grabbers. It goes deeper. Particularly in a state where there is much development and much activity going on lands. And the bottom line is this. Before the Land Use Act, all these Omo-Oniles were the owner of their lands. Government now came and said, well, I've taken over all the lands, or I've taken over that land. without any compensation given to them. And in their eye, you see government now selling the land to somebody else. Then, if you put yourself in their shoes, you definitely revolt. That is one of the major problems. So we need to go back and address that. You cannot expropriate somebody's property without compensation. And at the same time, allocate that same property to your friends and hangers on. So that is there. Another thing is that even when government now acquire this land for public purpose, there's what I call speculative compulsory acquisition schemes, where the government, have the purpose of building an airport, and by design and what have you, they needed only 10 hectares of land. The government will now acquire 35 hectares of land. They use the 10 meant for the, for the airport, and the remaining will just be there. Years in, years out, the thing will be there, nothing is happening. 10, 20 years after, nothing is happening. And before you know it, the government will just come one day, take another 10 hectares, now build some houses and start selling, or give it to a private developer to develop property, and that's selling. Meanwhile, the OmoNiles are stayed there. The land taken from their fathers some 30, 40 years ago is still there undeveloped. So speculatively, government has already taken more than it wanted. We have them in various parts of Lagos State. I can easily refer to war, which is very glaring. I think my father lost his land in that area. That Ojota, that housing estate in Ojota. The government said they acquire all those places and all that. But you discover they only develop a part. All this other side of that good road were later sold out, either by government or the OmoNiles. And when you buy from the OmoNiles, you want to do development and all those, you go back to government and get ratification. So you are buying twice. Agboyi, K2, my 12 axis is also there. It is scattered everywhere, speculative land acquisition. So until we go back to practicality and bring all those stakeholders together to discuss how we tackle this problem, I don't think we are getting anywhere. We only be treating the symptoms, leaving the cause.
So there's actually a law that's meant to guide the activities, just not enforced in law.
Yeah. There's a property protection law because there's in 2017. We set out criminal sanctions for some of the activities of these OmoNiles and what have you. But unfortunately, that has not called the activities of OmoNile.
Okay, let's move on to our next question. The prospective developer is about to acquire land for development in Lagos State through the land vendors. How can such a person confirm the status of that land before eventual purchase?
So, well, if I'm calling, I'll take two major steps. Visit the local Inco, visit the land itself. Do a physical examination of the extent of the land and any encroachment or anything, any interest existing there. Then more fundamentally, get to the Sub-Regional Service. That is the repository of all land maps of the state and their location as to use. At times you get land. It's only in Nigeria that you don't even go that deep. At times you get land. Yes, the land is free. You want to build a house there. You get there, you put your papers in for approval. They will tell you cannot build residential house there because that place has been earmarked for open space. It has been earmarked for commercial something. All those information, you will get it if you go to Survey General's office. And how do you do that? Filing your survey and seek for land information. Once you do that, it give you the detailed information as to the status of the land within the corpus of land in Lagos State and to what use you can put.
Okay, so after acquiring the land, what should a prospective developer do before embarking on actual construction, according to the law?
Well, acquisition of land is one. Perfection of interest in land is another. So after you have done the physical inspection, you've confirmed the status at the Survey General's office, and everything seems to be okay, then you can go ahead and acquire land. But you cannot ordinarily do any development. And that's the point. The next thing is to validate your interest by registering it. How do you register it? If the land has previous title, then you just apply for consent. Yeah, I think that's even a new rule, not too new rule. I think this one was done very new by external as AG. There's a Land Use Act documentation regulation, under which even though the land is not covered by existing registered title, you can still go ahead, prepare your document and submit for consent under that regulation. So the next thing is for you to get government, to get the land registered by going through the process of consent registration, or to put it more technically, obtain the CFO. Then when you have that, then you go ahead and apply. Do your drawings, call the technical people, the professionals who are involved in the nature of construction you intend to do. Remember, your search, your land information will have told you what you can use the land for. So in line with that, you do your drawings and everything, and then you can now move ahead and submit along with your title documents for processing of building, planning permit, and all that processes to get onto the field. Okay, so you said you were interested in talking about developers, right? So I think we can do that in the next question. What measures would you say government should take or put in place to ensure that developers willingly abide by the laws and regulations of planning permits? Okay, before I answer that question, let me first go to my own query. You see, most of these new rich developers that we have around now, development estate here and there, they end up getting what we call global CFO. That is, the land may be 12 acres, just get a CFO for that 12 acres. And they will now allot it into blocks and sell. In most cases, they are the one to do the construction for you, or they tell you they are going to do the skeleton or whatever. Develop into a closed estate. We have cases where the same developer has now used the CFO, the global CFO, to obtain loan from another bank. And that is the title that covers all the development in that enclosure. So it becomes problem. We have a lot of it along the Lekki-Ajah axis. That becomes a problem. It becomes a fraud, more or less. So one should be wary. them flaunting all this, whatever they call it, global seal of you should be interested, okay, am I going to get a registered title at the end of the day?
So are you saying they do not give titles to whoever?
Whatever they give you is equitable. The legal title is with them, that is the CFO.
So what if the person that purchases goes through the process of getting their CFO?
Yes, it is possible. It is possible. If you are ready to go the whole lot, it is possible. But definitely, it will be easier and less costly if it is done collectively. State also realizes that, okay, when you are in a group, your expense, there are be a common expense that we just cover instead of doing it unit by unit. You understand what I mean? So it is possible. And to get it done, that their global CFO, they must give you the particulars. Because that their CFO ought to be endorsed on by the state. That, okay, yes, this is the global CFO, was somebody who owns plot 22 has come and has obtained CFO, and that CFO is now registered against the global CFO. So that in the event they now use the global CFO to do something untowards, it will exclude the owner of plot 22. So it is feasible, it's doable. But do they really go ahead and do that? Do they even let people know that they can do that? They'll just be flaunting this global CFO, which means government has already given us the land for development, which is true. But who take custody of the CFO at the end of the day?
So how then would you say the government should make sure that these developers follow the rules, do well by whoever purchases land from them?
I think that is you see, the rule of property is caveat emptor, bias, beware. So it is incumbent on whoever is going to that field as a purchaser to arm himself with requisite legal or requisite professionals who can actually advise. But we are too quick not to spend money. You say, what are lawyers doing? So that's the problem. But ordinarily, you are supposed to go there with your lawyer so that any clause that is not too clear to you, you'll be able to get clarity and everything will be documented as to how to do it. Now to come back to your question as to what government can do to ensure that developers comply with the rules. It is in human nature to be deviant. Yes, except you set the standard, the rules yourself. It's human nature. So we need enforcement. And that is it. We need enforcement. I'm sorry to say this, the system is too corrupt. And there seem to be no consequences for infringement of the process, particularly within the system itself. What do I mean? Or how do I mean? You can build up to any level once you know whose arm to grease within the system. So, government needs to curb that. How? My own suggestion is this: get more professionals, private professionals, to do some of these supervisions. They have more at stake. If there's any problem, then the professional body can deal with them. In sane societies, or in saner societies, let it be that way, there's what we call professional indemnity insurance, which you must take as a professional to be able to engage in some of these things. It doesn't come cheap. So you know that you have not only your professional reputation at stake, you have pecuniary reputation also at stake. Unlike somebody in the civil service who is just passing the file. You go there, collect whatever he wants to collect. You may just keep the file somewhere, and the guy will have finished his house. It's only if something untoward happens that you now have this cries there and there, this noise and all that. Otherwise, a lot is going on that nobody's. But if they involve private professionals and engage them, particularly through their professional bodies, and you see, that is another hold on that professional to make sure this job is done. Compliance is what? Is key. The government cannot fund this thing alone. The government doesn't have the resources. And this will create job opportunities for a lot of professionals running around the streets, leaving the professional job and doing something else. I think that's my own approach to it.
That's very good answer. Now, you mentioned earlier, you talked about the area of government acquiring more land, or acquiring land more than they need.
Yeah.
Right. So at what extent or at what point do we draw the line between public interest and then protecting private interests? Because like you said, it is because these lands are acquired and the owners of the land are probably not compensated that we have the issue of Omo-Onile and land grabbing that we have now. So how do we, what exactly constitutes public interest, and how can private interests be protected in the process of land acquisition?
Well, I think constitutionally, we all have right to property. And by law, no individual property should be taken without proper notices, without due process, rule of law, and without compensation. With that, if we uphold that principle as enshrined in the Constitution, I think we will have solved more than 50% of the problem. Secondly, the government itself should be transparent. Let people see that, okay, you are doing this thing, you are doing it for them. Not that this underground networking in order to deprive people of their rights. So if the government is transparent and above board, I don't think Omo-Onile will complain if the government says, okay, you are acquiring this place for stadium, to build a stadium, and they could see the stadium springing up. They will even be able to go there and say, look, it's our parents, our fathers, our family that gave this land to government for stadium. And probably the government could even give them recognition in that enterprise. Maybe free access when they have, or named a particular standing for the family and all those things like that, to carry them along. But in a situation where the government only needs 5 and is collecting 20, and the remaining 15 is shared among who's who, I can tell you for free, there was supposed to be a stadium in Ikeja GRA. Go there now. It's fully developed. I think I can't remember the street now, but I know that area. Along the Ikorodu Shagam Road, just immediately after your office, around that axis, after the Jubilee Estate, that's supposed to be a stadium there. It was given to a private developer has been fully developed. So, you can't blame the Omo-Onile for buying that land. So these are some of the things government should do. Transparency is key. So that we will see that, okay, oh no, this government is doing this thing for us, and we should be happy about it.
Compensation, as enshrined in the Land Use Act, how can one go about it? Who are the professionals that you should engage in seeking compensation from the government according to the Act?
Well, before I even get to those who are to engage, let's talk about that compensation itself. Section 29 provides for compensation for acquisition, for revocation of right of occupancy, because, okay, I maybe I should need to give you this background to the Land Use Act itself. It is not by accident that what we have in the Land Use Act is right of occupancy. And it is not by accident that what we have is certificate of occupancy. So your right is just to occupy. You are not the owner. Yeah, you are not the owner. And this is borne out from reading section 1 and section 29 of the Land Use Act. Section 21 vests all land in the state, in the governor, for use and common benefit of Nigerians. Section 28 empower the state to revoke right of occupancy for various reasons. 29 provides for compensation where there is revocation. Now, to now confirm that all your right is just to occupy, you are not the owner. In section 29, what are the heads of compensation we have there? You have to be compensated for unexhausted improvement on the land. The underlying phrase there is unexhausted improvement. So if you have exhausted your improvement, no compensation.
What do you mean by that?
I will explain. If you have exhausted improvement, your improvement, no compensation. If there is no improvement at all, no compensation. Now, what do we refer to as unexhausted improvement? It's any development that you have put on that land, apart from its natural nature. Though there's recognition of economic trees and what have you. But ordinarily, beyond that, economic trees, if you have not put anything on the land, it is just bush. The government will take it and tell you, go home and see no more. Because there's no improvement or any unexhausted improvement. Now, to deepen the slab of section 29, the expression is unexhausted improvement. That means whatever improvement you have there is exhaustible. Which means it depreciates. So when it is unexhausted, it is what is left of that depreciation that you are paid for. So that means if you build a house there in 2020, the money you get for that house, for that building, is not likely to be the same if the house had been built in 1970. Because they believe that between 1970 and 2020, when they are now acquiring, you have exhausted some of the improvement in that property. Now, that is that. Now, as to who to consult, the law does not give you room for that.
Really?
Yes. The valuation for compensation is to be done by the surveyor, this government surveyor.
Acquiring?
Yes. So, even if you like, go and engage the president of surveyors. He has
So
no
what
role to play.
happens in a case where the value that the government surveyor, is not equal to the value, or according to you, the value of what you have.
Unfortunately, your view is, it doesn't matter in this case. Your opinion doesn't matter because the valuer is the government valuer that will do the valuation. And if you are disputing it, yes, you have the right to say, look, oh, this what they are paying me is not enough. It's not supposed to be. I'm supposed to get. You can only go to the Land Use and Allocation Committee set up under the law, under the Land Use Act, which is composed of the governor and all his appointees. And by provision of section 47, though that section has now been interpreted to be a nullity, but just by the letters of the law, by provision of section 47, you cannot appeal the decision of that Land Use and Allocation Committee. So where is fairness, where is equity when it comes to the issue of compensation? It's not.
Now, you mentioned something that by unexhausted improvement, it means that if you have a completed development, does that mean you will not be compensated?
Completed development?
Yeah, like completed improvement.
Yes, yeah. No, they will now take it, that's why I said, they will now take it from the date of completion to now and deduct depreciation. Yeah, that is what makes it unexhausted. For example, they may say, okay, the life of a building is 100 years, or let's say 80 years. That is, the expected life of a structure is 80 years. Let's take it like that. Now, they now acquire your property, which is already 70 years old.
So you pay for 10 years.
Yes! That is the unexhausted, because you have exhausted 70 years of 80 years. At least that is the language of the law there. If they use any other interpretation, they are just being more technical than ordinary. But the language of the law is unexhausted improvement. That is your improvement. If it has been exhausted, then you take nothing of it.
Okay, we're almost rounding off. Now, let's get into talking about a developer that's seeking to get planning permit. How can an aggrieved developer seek redress in case he or she is not satisfied with the planning decision? Let's say, for example, his application for development permit is turned down or delayed. How can such a person seek redress? Or he's given conditions that he doesn't think is favorable?
Well, I think there's a provision in the extant legislation on planning appeal committee or tribunal now. So that is where you are expected to channel your grievances. And if my knowledge of administrative law is anything to go by, you are mandated to go through that route. You are not allowed to jumpstart from the courts under the rule of exhaustion or under the rule of rightness. That you have a right, yes, but you cannot come to court. You have not exhausted the administrative procedure laid down for grievance resolution. So you will be asked to go back to that committee to resolve your problems. I think there's a provision like that. So developers should just take it.
Let's talk about wills. So an average Nigerian who owns properties, when you tell them to go get a will or write a will, they start to think you're planning their death, right? At what stage of one's life do you think it is necessary to begin to consider writing a will?
Well, I think the right to own property in Nigeria, if I'm right, I think it's 21. Because I think the Land Use Act says that if you are less than 21, then they cannot grant you a CFO except through a guardian or whatever you use. So the right to property is 21. So that means on attainment of the age of 21, you have every right to make a will. Because once you are a person of property, then you have a right to make a will. If you have something to leave down, you have a right to make a will. And note this, death doesn't have a date. It comes when it comes. It doesn't have a color, no tribe, no age. So anybody can die anytime. But the fact that if you are still under 21, you don't have legal rights to properties. So what do you want to give when you don't have a right to it? But once you have a right, which is at 21, then you have a right to make a will. And it is good to make a will. It is good to make a will because it takes away a lot of stress from the family after your death. Yes, there may be dispute as to it here and there, but the fact that you have put down your thought as to how your property should be distributed upon your death cannot be taken away. So it is good to make a will once you know you have anything to leave upon your death.
So for a layman out there who is wondering, okay, I want to have a will, how do I go about that?
Well, I think the best thing just get in touch with a lawyer. Let me first say that it is not exclusive that a lawyer must do you a will.
Oh, really?
Yeah, you can do it yourself. Yes. The only reason why lawyers are usually advised that you should go to a lawyer is that look, the lawyer knows the technicality of how to draft it. For example, you may have a property, just one, and if you now want to leave it to your wife, but you don't want your wife to sell it. You want your children to now get it after you die. Yes, you may have that idea, but how to put it down as a layman may be a difficult thing. But for a lawyer, he knows that he has to create a limited interest in the wife and unlimited interest in the children. Not only that, you may want your properties to be shared in a particular ratio, or one conditional upon the other. Say, for example, you have given your properties, you share your properties to your children. But what happens where one of your child to whom you have given your property died before you? What happens to that property? You may be at loss. A lawyer will be able to guide you. Okay, you can do it this way, you can do it this way, you can do it this way. So that is why it's usually better to get a lawyer to do it for you.
My final question, if someone dies, how can his or her landed property be administered by the children legally?
By law, any intestate property is to be administered by a letter of administration, while tested properties is to be administered by probate, which means if you made a will in your lifetime, then those you appointed as executors, executories in the will will take charge after obtaining government approval to that disposition. You take charge and manage the property the way you have laid them out in your will. Where the person now dies without a will that's intestate, the rule is that you need to apply. Members of that family, the beneficiaries or survivors or whatever, will need to apply to the state, to the probate court, for the letters of administration, listing the number of people who they want to be given that property, given that right, and the properties of the deceased that they want them to manage. So if government gives approval to that, if the state gives approval to that, then those administrators will be the one to legally manage the property of the deceased. That's why I put it. Well, I want to believe that my customary law experts, they also say that, look, we're only talking of written law. Suppose the person live his life under customary law and practice, and he has decided that his estate should also be managed customarily. Yes, in that wise, I think I'll leave it to the head of the family and what have you. But unfortunately, they will still have to face some legal hurdles, even where they are not. They will seek not to go and obtain government papers because nobody will recognize them outside beyond the family setting. If somebody challenge them, they may have a problem. So more so, by statute of fraud, anything that relates to landed property is expected to be in writing, evidence in writing, and signed by the person to be charged with. So that is it.
Wow, thank you very much for your time, sir.
It's
really been an educative and enlightening session with you. Thank you so much.
You're welcome.
I'd like you to say a word or two about the Cable Plus Property Media outfit.
Well, just like I said at the preambles, I think this project is a very good one. If it can be replicated by so many other organizations, I think we are going to be good for it at the end of the day, as a society, as a country, as a state. Because a lot of people you see around, they just go around without the knowledge they are supposed to have at the tip of their hand. And that makes them exploitable by other members of the society. So if you have a project like this, a program like this, where people are given opportunity to listen, to be enlightened, and to be educated about what goes around them, about their property rights and what have you, I think it's going to go a long way. So I give kudos, thumbs up for the organization for putting this together. And I wish them more horizon
Thank you, sir.
in the practice.
Thank you very much, sir.
Yeah, you're welcome.
And you just learned all that you need to learn about the legality of procuring land or obtaining permits or acquisition, how important it is for you to get a will as long as you are age 21 and above to get a will, because, death could come knocking at any time. Thank you so much for watching. This is where we draw the curtain on the Cable Plus Property Show. Don't forget to share and comment. Share our videos across our social media handles at Cable Plus Property. Make sure you click the subscribe button below, turn on notifications, and let this video go viral. My name is Oiza, and this is Cable Plus Property.